All right. Just going to give it a second as everyone who is in the waiting room is able to join in, and then I'll start the CLE. Well, thank you everyone for joining today. My name is Todd Hefner, and I'm currently the treasurer of the Georgia Bar Association construction section and a construction associate with Troutman Pepper. I'm going to try and do as little talking as possible today, and that's because we're really excited to welcome 5 incredible construction arbitrators from across the country who have graciously agreed to join us. If I were to list our panelists' many accomplishments and accolades, we would hardly have any time for what we're here for, so I'm going to keep the introductions as brief as possible. Patricia Galloway is an international arbitrator specializing in energy and construction matters with more than 40 years experience in U.S. domestic and international arbitration. She joins us all the way from Washington State. And in addition to her work as an arbitrator, Patricia is the chairman of Pegasus Global Holdings, a mega project management firm. Marion Hack is a member with Cozen O'Connor in Los Angeles. Marion has focused her legal career on the construction industry and is a highly respected first chair trial attorney. In addition to her work on behalf of clients, she regularly serves as a mediator and arbitrator. John Hinchy, now with JAMS, was formerly a partner here in Atlanta at King & Spalding. John is recognized in the United States and internationally as a leader in resolving significant commercial disputes as a mediator and arbitrator. Allison Snyder now exclusively serves as an arbitrator, mediator, and dispute review board member and is based in Houston, Texas. Previously, Allison was a construction litigator in private practice, where she was most recently with Porter Hedges. And last but certainly not least, Tony Smith, a partner with Weinberg Wheeler here in Atlanta. Tony has devoted his legal career to the construction industry, and when not working on behalf of clients, he regularly serves as an arbitrator. Just want to again thank our panelists. I think I speak for all of the 68 attendees currently logged in when I say we're excited to have you. As I said at the outset, I kept these introductions as brief as possible. Suffice to say, our panelists have been awarded every applicable recognition you've heard of, and at least a dozen you haven't. So I'd like to start, before we get into the meat of today's topic, with the relatively recent amendments that happened earlier this year to AAA's construction arbitration rules, which became effective March 1st. In everyone's CLE materials, you should have a copy of AAA's summary of the changes. The changes that I found notable: modified consolidation and joinder, providing AAA the ability to limit the party's strikes, and there's also a lot of other updates in there. So the first question I'll pose to our panelists is this: is there anything in these updates that stood out to you, either good or bad? And Allison, I'll throw it out to you first.
Thank you, Todd. I think the thing that will impact all of us at some point or another is the joinder and consolidation rule. I think we've all struggled with the fact that sometimes joinder impacts a case, the timing of the case, and allowing the case to progress and move forward. This new rule change that requires that joinder motion to be filed before the merits arbitrators are confirmed, I think will speed things up a great deal. We know there are going to be cases where parties have to bring a joinder action later, but hopefully that will be a situation that's few and far between, and we'll be able to not have so many cases affected after we get up and going with a scheduling order by the move to bring in a bunch of new parties late in the game.
Marion, any thoughts on the new rules or anything Allison had?
I'm glad they moved the threshold from 1 million to 3 million for 3 arbitrators. That was just a huge issue and cost a lot of, $1 million case does not really warrant a 3 arbitrator panel. It was sort of the full employment act for arbitrators, but I just didn't think it was really warranted. So that has been a really interesting change and important. I'm not as thrilled about the authority to clarify the words, modification of words, because I feel like that might be abused by counsel, because I'm just asking for a clarification, which is really just asking to re-argue the award itself. I do like it being limited to clerical or typographical or technical errors in the award or issues, but when you ask to clarify, my worry is that we're gonna open the door to more advocacy when really the proceedings are over. Those are my two comments.
Well, in general, it seems to me that the new amendments are trying to make the AAA rules a little more efficient and consistent with what most arbitrators, I think, typically have done in most arbitrations. For example, in Rule 34 on dispositive motions, the AAA has amended that rule to add a requirement for arbitrators to consider the cost of a dispositive motion in determining whether or not to grant leave for a party to file a motion. And I think that's a factor that most arbitrators have already taken into account. And I would guess that, most still do as well. On sanctions in Rule 60, that rule likewise has been amended to confirm that the arbitrator does have authority to impose sanctions on their own initiative. I think many arbitrators have done that in their practice, but I think in doing that, it's going to require a great deal of caution, because that could very well lead courts to intervene in arbitration, and that's something, of course, that neither the parties nor the arbitrators would want to encourage.
Just to follow on what John said about dispositive motions, I think the sort of the admonition here to take into account the cost of the filing we might actually see more motions denied because of that, because I think John's right, we do take that into account, but I don't think you consciously do it as much as you might now with the rule change. And we might see it cited more in orders denying the opportunity to file a motion.
Yeah, and that's true. But, I hope that we don't lose that ability, because I personally like dispositive motions. If they're good, I like to be able to narrow the issues going in, or even potentially dispose of the matter if it warrants. And obviously, if we, don't have material facts in dispute. But I have found it to be a very useful tool into narrowing the issues. I've had probably in the last couple of years, 2 or 3 that have dispositive motions where we completely dismissed the entire case, and 2, got rid of some what I would call issues that would have taken up a lot of time and would have been costly for the amount of dollars that was actually being claimed. And so the cost versus what you're saying versus the cost of actually trying those issues far outweighed the ability to take that motion and get rid of it. So I hope that parties appreciate the fact that not only and the arbitrators consider, what is the cost of the dispositive motion, but look beyond that to see what it is that is trying to be disposed of, and what those costs, those damages are, and potentially recognizing that it would be beneficial to everybody to get rid of those issues beforehand. So just hope we don't lose sight of that as we're looking at those costs.
Pick up on the discussion about the Rule 34 changes. I know we all agree that arbitration should be an efficient and effective procedure for resolving disputes among private parties who've already agreed to the procedure, but counsel and their clients can really screw it up and make it inefficient and time consuming and more costly. And it's up to the panel to control that process and make sure that that doesn't happen. I see that as one of my primary roles on a panel. So I look at Rule 34 as a good change, and one of the changes that the AAA has made that should make our ability to control the process more easily handled.
For the remainder of our time together, I plan to walk through kind of the various phases of an arbitration, and generally focus my question on what constitutes effective advocacy at each stage. And we can obviously take this any direction that is interesting to our panelists. And I'll leave some time for Q&A at the end. You can also use the chat feature to send me questions at any time. But before I get to my next question, real quick, want to highlight two things in this packet of CLE materials that you should have received. The first is an article from a construction lawyer that highlights some more recent survey results conducted regarding construction mediation and arbitration. And the second is an older survey from 2015 that the ABA Construction Forum did. They got responses from over 200 construction arbitrators, and I still find it a very useful document when trying to understand arbitrator preferences. And so the first question I'll ask is related to actually in the older survey, question 5A, which gives some results about arbitrator selection. And so there's obviously a lot of different ways you can be selected. You can be party appointed. You could be the chair voted on by the other arbitrators. You can be the result of a rank and strike process. But the survey says when it's party appointed, about 2/3 of the time, arbitrators are in fact neutral when being party appointed. So that means 1/3 of the time they're not. In your experience, how accurate or not is that? And in any way, how does being appointed, the different ways you can be appointed, perhaps affect your role? And John, I'll start with you this time.
Well, ideally, I think it's right for a party-selected arbitrator to act in a completely impartial manner throughout the arbitration. But at the same time, I also accept that realistically, there are several, motivations and tendencies that tend to cause arbitrators to act otherwise. First of all, the appointed arbitrator is probably grateful, for the appointment and may feel that he or she, might owe something to the appointing party. And then secondly, it's likely that the appointed arbitrator is hoping for repeat appointments and is naturally going to be reluctant to offend the appointing party. And then thirdly, I think there's one school of thought that a party appointed arbitrator has some sort of implicit obligation to do whatever is reasonable and consistent, and again, within the rule of ethics, to make certain that the other two arbitrators clearly understand the position and the arguments of the appointing party. But again, I think the preferable approach is a completely neutral and unbiased attitude, which, although sometimes can go against the grain, I think can and should be the prevailing mindset. And it's been my experience over the years that the vast majority of other party-appointed arbitrators that I've been involved with have acted in a completely neutral and unbiased fashion.
Just to pick up on John's comment, I know we've all done dozens and dozens of arbitrations. I was amazed at that 1/3 statistic from 2015 indicated that at least at that point in time, the high number of arbitrators were coming in and acting as a party advocate. In all the arbitrations that I've done, I've never seen an arbitrator act in a non-neutral manner. It's never happened to me. If I knew that I was being appointed to a panel where the party-appointed arbitrators were going to be non-neutral, I don't think I'd accept the appointment.
Well,
Yeah,
I think sorry, go on.
I would agree that I have, I've never been on an arbitration panel where a party appointed arbitrator, quote, has been an advocate for their party. However, I think there's a slight nuance, and John sort of touched on this, and that is, I think that sometimes a party appointed arbitrator, while still being completely neutral, sometimes feels that they have an obligation to at least make sure that the party that appointed them views are heard. That doesn't mean that they're advocating for them. That doesn't mean that they're going to rule in their favor, But I do see, and sometimes I even see myself, of just making sure that the views are heard. And that's, sometimes difficult. And so I think that party appointed arbitrators, I don't know how this survey came about or what triggered that 1/3, but I would add that potentially those types of things might have some counsel thinking that it was an advocacy, where in my view, it's just making sure that it's a fair and efficient process, and that the party that appointed you also gets a fair and reasonable process at presenting their views. So that would just be a little subtle ad that I would have on a party appointed arbitrator.
Go ahead, Marion, and then I'll make mine.
No, I think I agree with everything that's been said, Allison. Go for it.
Okay. Well, I was just going to make the comment that I had 2 occasions where it was a party appointed case, but the clause in the contract required that the AAA not disclose to the party appointed arbitrators who appointed them. And it was very interesting because we were appointed, told we were party appointed, not told who did it. I'm sure there are situations where you could easily figure that out. But in the first case, I had not dealt with either party, and I really couldn't figure out who it was. Naturally, the other party appointed, asks, who appointed you? I don't know. Who appointed you? I don't know. And we never did figure it out all the way throughout the case. Very interesting, though, that without that knowledge, you feel differently. There's just the pressure that is there inherently when you know who appointed you is not there when you don't have that knowledge. And a very interesting and I think rewarding way to go through the process. In the second case like that, it was not in the party's contract, but post-contract submission, they agreed to do it that way. I'd like to see more of that, actually.
Many of the cases that I've been in, and this may be because I'm just old, but somewhere along the way, I've forgotten which party appointed me. I don't even remember. So it doesn't really matter to me, but I've forgotten.
All right. I want to talk about pleadings next. Given that arbitration is far less formal and there is far less boxes, well, there's the 2-page form under AAA rules, and you can get away with just filing that. I want each of you to think of maybe what's one of the most persuasive pleading documents that's ever been put before you in an arbitration. And this time I'll start with Marion. What actually makes for a persuasive pleading in arbitration?
Well, you mentioned, the initial filing, you only have the 2-page. I will say that at the early stage, a short explanation of the case is really all I need rather than the full-blown pleading. So if you use me as an arbitrator, you can save your money on that because at that point in time, that's really all you need. You're not going to make any decisions or anything like that. And there's a lot of superfluous stuff in that pleading that you really don't need to know. So a good, effective, just explanation of the case, where the parties are at, is perfect at that time. As to being an best effective pleadings I've seen, I think one thing I would recommend to anyone who does do a lot of arbitrations on the advocacy side, I do both. I do the arbitrations on both sides of it. And when I moved over to being an arbitrator, it really informed me what was persuasive and what wasn't. I couldn't see it when I was on the advocacy side as well. And I would highly recommend anyone to do where I started out is doing the small fast track arbitrations. And a lot of those go to hearing, by the way. And I found that you don't make any money doing that. It's like you get like $17.50 or something that says flat fee, but you learn a lot about what is effective advocacy. Of course, you learn about what isn't effective advocacy also in those proceedings. But the one thing which struck me is that we're so used to writing pleadings and you have to understand the arbitrator has to write a decision. So the pleadings that have been the most effective are the ones that are written almost like a decision, like this is how you should, this is how, if I was to write the decision, this is how it would look. And that has been very helpful because a lot of times you look at that and you realize that's a very good way to put it at, set it forward. But think about the arbitrator and what they have to write at the end of the day. And if your pleadings are sort of matching that, it's much more effective advocacy than doing kind of your straight standard pleadings that you're used to doing in the court.
Yeah, I'll add on to that, Marion, that in that vein, I like to see pleadings that very discreetly identify the issues the arbitrator is to decide.
Please, very helpful.
And I have to tell you, I see an awful lot of
happen.
that seems like a very simple concept, yet they seem to just blend and intertwine and go on with argument. And sometimes it becomes difficult to decipher exactly what it is of the issue that is to be decided. And so if anything that I can add to what you've said, which I 100% agree with, is to please discreetly make sure that you identify and only identify those issues that are to be determined and decided in the award.
Well, for those of us who have done quite a few international cases, and I know that all of us have, we typically see very detailed pleadings, even the initial pleading and the initial statement of defense generally lays out the positions of the parties in a great amount of detail. Personally, I find that very helpful. And whenever the case is appropriate, I like to see that in a domestic U.S. case as well. But it also, I think, serves an additional purpose, and that is to aid the parties in their discovery process. In other words, they can be much more focused in their requests for documents, and even if they're going to be taking depositions, when they're taking those, to know more about the actual facts of the case and which documents are going to be relevant and which witnesses are going to be testifying. But I also recognize from the advocate's position, not all of the facts or documents are going to be known to that extent at the beginning of the case. And there may also be some strategic or tactical reasons for holding back on full disclosure of the case. But my advice to the advocate would be that if and to the extent that the facts are known at the beginning of the case, and there are not other mitigating factors that would cause you to want to do otherwise, then I think it's very helpful to the arbitrators to present those facts in as much detail as possible in the initial pleadings.
Yeah,
Well,
I would agree.
Go ahead.
I'm sorry, Tony. I would agree with that. And the other place that I think the earlier the better is getting information across to the arbitrators about your damages. So goes hand in hand with what John was just describing. But, I think we all see cases where the idea of the types of damages, the quantity, it's very late in the game before either we or the opposing counsel get enough information to really help out with whatever it is, whether it's discovery, whether it's a possibility of mediation and settlement sometime during the case. That information should come much earlier.
Actually, it should come. I think what I've seen is a lot of discussion of liability, and they forget there's damages, and it's sort of an afterthought. And it's not the afterthought. It's really important. And that's the biggest mistake I see constantly, not only in litigation and in arbitration, is not focusing on damages and proving up those damages. It's like I get briefs of, 50 pages of liability, and I've got a paragraph, and this is what we're owed. You got to prove up those too. And it is consistent error I see with advocates. And it's so important because that's really the meat of everything. But anyway.
I think those can be handled in the initial procedural scheduling order, where you can require a detailed statement of claim by a certain point in the process. you can require detailed statement of damages by a certain point in the process. And that's what my practice is to set those dates and hold the parties to them. In terms of the initial pleadings, I agree with Marion. I don't really want anything more than just a general outline of what the claims are about, because we've got a lot of time to get into the other details. But I do set specific times on that. And to the extent we're going to talk about closing out the hearings, which we've jumped into a little bit in terms of the final briefing, I'll save my comments on that until we get to that point in Todd's outline.
Can I just add something really quick, Todd, on the damages that Marion talked about? Because not only do I agree with that statement and very seldom see the detail that I would expect to see, but I also like to see in the alternative, and I also like to see the opposing party say, if they were to lose, what those damages, not just a statement saying, oh, they're overstated. All right, overstated by how much? If you lose the argument, what would reasonable damages be? I know counsel hates to do that, but I will tell you that an arbitrator is not going to recalculate damages. And so if there's not a number there for the arbitrator to choose, they're going to choose the number of the winning side of how they're going to determine. So I just encourage counsel to think about alternative damages, or if they potentially lose an issue, what how those damages, quote, are overstated and why and by how much, and to give the arbitrator some leeway to potentially reduce the damages if they are, quote, overstated. So I just wanted to add that relative to damages.
All right. Let's switch to scheduling orders and preliminary conferences. I know some arbitrators are more than happy to just let the parties put together the scheduling order and the kind of case management order. Other arbitrators prefer some of their preferences be met more so. I'm curious, what's a provision you pretty much always require in a scheduling order? Are there any things you've picked up over the years that are just very useful to the overall process? Tony, I'll start with you this time.
I just typically use the AAA's form and require the parties to go through that. I think that covers, at least from my perspective, all of the matters that need to be covered and scheduled in the initial procedural order. There's a comment in here in your outline, Todd, about how much advocacy do you expect or want in the initial preliminary conference from counsel. It can be overdone, in my view. It can be underdone in terms of none whatsoever. I think as long as counsel are respectful and cooperative in their approach to putting the procedural order together, the initial procedural order, I expect some advocacy, and I appreciate some advocacy, but it can be overdone.
One thing I have moved to is that in the initial scheduling order, I request that all parties send me a list of their witnesses and experts as soon as possible, within 30 days, understanding that they may change experts or they may add people, but especially for people who are still practicing like myself, I have seen, and I haven't run into this, but I've been taking over cases where this has happened, where you get to the finish line, about to have the arbitration, the experts are disclosed, the arbitrator has to make another disclosure because either they've cross-examined that expert or used that expert, and all of a sudden you've got an arbitrator that's been dinged and you're starting over. So I think it's very important early on to identify any conflicts that are possible. And I do that. Sometimes the parties are willing to do the witness list, exchange them. But if they're not, I have them do it private confidentially. So at least we can figure that out as early as possible, with the ongoing obligation of parties. If they are going to hire another expert, they do have to let me know so we can clear conflicts as soon as possible.
You know, Todd, there's an additional type of information too that I have often found very helpful in understanding the nature of the issues in an arbitration, and that has to do with the physical aspects of the project. For example, if you're dealing with a nuclear power plant or a solar power plant or a wind turbine plant or a piping project that's very complex, or a chemical process plant, it's very helpful to the arbitrators who may only have general knowledge about those topics to have more detailed knowledge about how those processes actually work, to have perhaps pictures of the project or the process in question, to have diagrams, just to understand the general physical aspects of the project itself. One of the things that I've found most interesting about my practice is that in the construction business, in the construction world, every project is like the Discovery Channel. I mean, it's a whole new world of knowledge that's just fascinating to me. And to learn about that, particularly at the beginning stages of the project, is very helpful, because we're going to be reading reports, we're going to be reading depositions, we're going to be reading pleadings. And the more we know and can understand about those physical aspects of the project, the better prepared we're going to be to decide the case. I agree with Marion. I think a list of the participants of the case, the organizational structure of the companies, and we see a lot of acronyms in cases, and I think it's very helpful for the parties at the beginning of the case to give the arbitrators a glossary of terms, that we're going to be seeing in all of the pleadings, and certainly if they can do it at the time, a chronological timeline. So those are just preparatory documents that can be very helpful to the arbitrators, I think, in understanding what they're going to be seeing later in the case.
Yeah, and I'll add to that, John. I agree with everything that you and Marion have said that is really good to discuss at the preliminary conference. I find that the AAA form doesn't always include everything or is in detail that I would like to see. So typically, I send out a letter to the parties before the preliminary conference. I usually like to get it out at least a week, maybe 2 weeks before the preliminary conference, that goes over every item that we will be discussing at the preliminary conference, why it's important, and to give some detail for the parties to think about. For example, I mean, let's just take expert witnesses. I mean, there's one thing to say you're going to talk about expert witnesses. I like to go a little bit deeper, and I say, are the parties willing? And I don't say, do you want? I say, are the parties willing to discuss having the experts meet and confer? Are the parties willing to develop and prepare a joint expert report that will be submitted to the panel? Are the parties willing to hot tub their witnesses, at the hearing? If so, how will that be done? Will it be done just via cross? Will it be done just by the panel? Will it be done by having the experts, cross each other? And so I like to go through a little bit of detail, including like witness statements versus just direct. And I know we might be talking about that a little bit later. But that's what I try to put forth. So by the time, and I ask the parties, you need to meet and confer and go over this before we have the preliminary conference, and let the panel know on which items you can agree. And if you disagree, why you disagree. I find that it makes the preliminary conference go a little bit faster, because if they have discussed and agreed on things, we don't need to spend a lot of time talking about it. We will just back up once we have hearing dates that we talk about, put dates that are due. But then we can focus on those items, why the parties disagree and why they disagree, and then have a discussion on that. So just one more way that I typically try to handle the preliminary conference and the outline that goes out beforehand.
I will add to that. I oftentimes send out a template for a scheduling order that I use before the preliminary hearing. Sometimes the preliminary hearing comes so quickly that you don't get a chance to do that. And then I will send it out immediately after the hearing so the parties can use it as they put together their dates. But a couple of things I find really useful in the order is the language that does not allow the parties to cancel a status call if they don't think there's anything to talk about. There is always something to talk about in managing a case. And, sometimes parties will just put in that language that says, If they don't have any agenda for that call, they can cancel the call. And I always strike that because I think the calls are very useful. I have an agenda even if they don't. And I think those check-in calls are extremely important for management of the case. Another topic that I like to see handled in more detail than the normal AAA forms is on subpoenas, because subpoenas for discovery and subpoenas for the hearing itself, parties usually don't give enough time to it. They don't plan ahead for it. And so the procedure that needs to go into that process on both discovery subpoenas and hearing subpoenas, I like to have a little bit more control over that. So I have a procedure in there that in my template that I think gives a little more detail and a little more help in managing the case. The other thing I would say about preliminary hearings is people need to come into those hearings knowing everyone's availability. I'm always surprised when, the lawyer will bring his or her calendar to the hearing, but I'm always surprised when they don't know their client's availability, they don't know their expert witnesses' availability, and you're sitting there fumbling with dates anyway. And then when you select a date with all the lawyers' calendars and the arbitrators' calendars, but you don't know, the main players and their availability, it really makes things uncertain and much more difficult to set that calendar in stone. So I just think counsel needs to have done a lot more preparatory work in terms of the schedule. And I know it's hard to know what time frame are we looking at, but if counsel has conferred with opposing counsel, and then, sometimes counsel will reach out to the panel. Sometimes the panel will reach out. Sometimes it doesn't happen until you actually get to the preliminary hearing. But if you know the next year of availability for your witnesses and your experts, you don't have to go through that uncertainty process.
Thank you for all of that, Allison. I kind of want to pick up on somewhat related topic to what you said about subpoenas. I've actually gotten a question for what is your all's practice when there is parallel litigation? Not every dispute allows for all of the parties to be joined into the arbitration, or there might be certain things that require relief from the court, and that can butt up against the design of arbitration to be efficient. Courts are notoriously slower in most situations. So what if a party comes to you and says, we need to put the brakes on this and allow this parallel litigation to play out, or how have you ever dealt with that situation? And Allison, I'll let you start because you mentioned the subpoena topic already.
Okay, so are you talking about it in the context of subpoenas or like a motion to stay the arbitration until the issues in litigation get hashed out?
Well, it doesn't have to be exclusive to subpoenas. I just thought that is a somewhat related concept. It can be because there's a motion to stay, but it could also be that courts have already decided these are just going to proceed in parallel. How do you deal with that, if at all?
Well, I would say that typically it is what we would call a hot mess, because it depends on the court and the arbitration panel and the issues and the parties, but it is always complicated. Putting subpoenas aside for a minute, because that's a whole nother topic that I'm sure we'll get to this morning a little bit later. But just from the standpoint of what proceeds in arbitration and what proceeds at the courthouse and the interplay of those two, I think it's really important that the panel figure out exactly what issues are in play at the courthouse and what issues are before them. And you will find that parties ask panels all the time to do things, tell the court this or tell the court that, or panel, you have the jurisdiction for this, the court does not. You should tell the court, state court judge or federal court judge, blah, 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 which obviously we can't and won't do. But figuring out with clarity where the line is and what issues are before, each of those fact finders is very important. We all have cases where somebody's going to come and say, and it happens particularly where, let's say, an owner and a contractor have a dispute at the courthouse, and then the contractor has all the subs at arbitration. And in a situation like that, where those proceedings go along in a parallel universe, that can be really difficult. Whereas if one of those, if the owner contractor proceeding goes ahead first, and there is some finality to that decision, it may well impact what happens in the arbitration. So sorting through those issues quickly and early on in the case, I think, is imperative. And that can be done on the panel's own initiative or through a motion to stay that one of the parties files.
I will admit that it's a hot mess, Allison. I had an example of a major dispute, and this is sort of a advice to counsel. So there was a dispute, and under the clause, it was a public client that it had to go to court. Arbitration was not an option, and so the matter found itself in federal district court, and included all parties such as the surety, the contractor, the owner, subs. I mean, it was massive number of parties. Unfortunately, the contractor had a parent guarantee, and so the contract with the parent guarantee, written by the same company, but that was an arbitration clause. And so that was under ICC rules. And that parent company filed an arbitration with the ICC in parallel to the owner, because it was a wrongful termination case, filing the court with the federal district court. And they were going on in parallel. Now, both matters actually settled. They did not go to a hearing, but the issues that were before the parties were the same, because of the arguments that the parent company was making relative to, quote, not having to pay the parent guarantee because of the wrongful termination. And so there were dangers, obviously, to all the parties as to what was being done in discovery, right? Because you have the federal rules, everything was allowed in discovery. You had the ICC panel that not everything was going to be allowed in discovery, and the issues treated much differently. And it was very difficult for the arbitration panel, right, to try to ferret through it, knowing whether or not there would have to be a stay, or which would go forward first. Obviously, the arbitration was apparently going to be going first, and then how that would affect the issues in the case in federal district court. So lesson learned, make sure when you're doing contracts counsel that they all have the same clause as to not dividing up the different venues.
And it's not always, the arbitration panel that has the the say on that. I had a case where a contractor had a proceeding against an owner. Well, it's really the owner against the contractor in the courthouse, and then the owner versus the architect in arbitration. And the contractor went to the court and said, let's stay this proceeding while the arbitration proceeds. And the court said no, and allowed both to go forward in parallel. Interestingly, that nobody came to me and said, why don't you stay your proceeding? So they did go ahead in parallel. So, it's not always something we get to make the call on. But again, the trying to marry those provisions and make sure that they're consistent in the various family of contracts that's involved in a project is really critical. We see it play out every day where it has not happened, and then it makes litigation and arbitration incredibly expensive.
Yes.
Arbitration going on parallel with attendant litigation happens all the time, and There is no template. There is no set way to handle it. It has to be handled on an individual case-by-case basis. It depends on the parties. It depends on the court. It depends on the arbitrators. But Allison is correct. It's always a hot mess.
Right. I want to pause the kind of march through the arbitration process and do a couple, hopefully lightning round type questions. We'll do it with Allison going first. What's the most obscure location you've ever conducted an arbitration?
Oh gosh. I really have not been to the far reaches of the earth. Probably I've done a couple in South Texas in the Valley down in Harlingen or Beaumont. And all around the Northeast and the West and the Southwest, but nothing really obscure or weird.
John, I'm sure you've got some obscure location you've been to.
Yeah, I spent 3 months in Mumbai, India, and over a we did the hearing in 3 different tranches, and it was a travel challenge to to manage that and to actually manage all the logistics and everything that had to be done over there. And just preparing to go to India, if any of you have been, is a challenge in itself. You spend a lot of time getting inoculations and shots. You spend a lot of time getting visas. We even had what was then known as kidnapping insurance and travel insurance to make sure that if we were kidnapped or something like that happened, that we might have a chance of getting out and getting home. It was a classic arbitration that went from the very beginning all the way to the final judgment, and then the case was ultimately appealed. But it was a fascinating experience.
Can anyone top that?
Nope.
No.
I can't top it.
Nope.
John was there for 5 weeks, but I did spend a week in Dar es Salaam, Tanzania on a power plant project and was not sure that I was going to get out.
All right. The next lightning round question. Have you ever had to kick a fellow arbitrator under the table?
No, but I've had to wake
keep him
one
awake.
up.
I have
Yeah.
had to take a break and have a really serious conversation, but I haven't kicked anybody.
A polite way of getting at my question.
Yeah.
Yes, I've had to kick somebody under the plate. I think it was Hinchy, but I'm really recall right now.
Yeah.
Right. And the last one of these questions I have is, have you ever had to yell at one of the lawyers appearing before you?
Oh, yes.
Yell.
Oh, yes.
Yes. To yell at the attorneys appearing before you.
I had a very interesting, it's a fast track arbitration in the contract, very well defined as to when, from the time of panel constitution to the award being delivered, extremely fast track. And the lead counsel for one of the parties stood up and said, not going to be able to make this because I'm actually in court and I don't have the opportunity to do this arbitration at the same time. And so we're going to have to ask for a postponement. And of course, this was on the first day of the hearing, not at the preliminary conference, but the first day of the hearing. And so, and I was chair and I said, well, that's not going to happen because the parties have decided in their contract as what we're doing and we are proceeding. And he proceeded to like yell at me, indicating that I didn't have the authority. And then I very calmly, in my stern voice, said, actually, this panel does have authority, cited the rule. And then I said, and your co-counsel who is sitting next to you, I'm sure is extremely capable of handling this matter. And so I would like to have your co-counsel present the case going forward. And he was very, very upset, huffed out of the room. Co-counsel did an amazing job. We finished the hearing and everything within the contractual time period. And things went on. So it was an interesting dynamic on day one.
But Marion, any?
You do have to be stern sometimes. Some people, they have to be reminded that this is no different than appearing in court, and that this is a judicial proceeding, and you have to take it seriously with the same decorum that you would take a proceeding if you were in front of a judge. I have had to make those reminders many times. But other than that, and sometimes you just have to be firm with people. I've had some litigants that have just been out of hand, unfortunately, but we've righted the ship, but yes, so it has happened.
Yeah, I've had situations, I had one situation where the counsel for the respondent disputed the authority of the panel to do anything and refused to go forward. And so we excused him from the room and let the claimant put on their case and confirm the judgment. Claimant did very well in that manner.
All right. Got to go back to the outline, unfortunately, and now we're on everyone's favorite topic, which is discovery. And in my experience on large arbitrations, that while we might skip requests for admission and interrogatories and things of that nature, the nature of document requests essentially mirrors what you might find in litigation. And so I'm just curious, what will actually cause you all to limit discovery beyond what it's kind of grown into?
Todd,
John, start with you.
if you, first of all, as a preliminary to addressing that question, I would urge the parties in all cases to try to settle the case by negotiation or mediation, if at all possible. But if the case cannot be settled, then I think justice requires that the issues be tried and decided based on the contract and the applicable law. Now, my philosophy on discovery, and it's somewhat controversial, is simply this. The reality is, if all the facts in the dispute could be known at the hearing stage, then there would be absolutely no need for a hearing. And a perfect example of that would be like a jigsaw puzzle. If we had all the pieces, we could put them together on the table, we would see exactly what the picture looks like. But of course, when we get to the hearing, we don't know all the facts, but it stands to reason that the more facts that can be known during an arbitration, the more likely it is that the arbitrators can accurately and justly decide the case. Now, that means if we want to decide the case in the most accurate and just way, we need to take reasonable and appropriate steps to obtain those facts in the context of arbitration discovery. But we all know that discovery is very expensive and it's time consuming and it cannot be unlimited. So I think we have to strike a balance that's based on the desires and the needs of the parties, the accessibility of the facts, and the relative cost and the time involved, and then come up with a rational and reasonable discovery plan. And doing that, I think, requires the best experience, the good judgment, and the honesty of the arbitrators and the parties. It is not a perfect process. It will never be perfect, but I think it can be effective to decide cases in a fair and just way. I've over the years, there have been prevailing differences in schools of thought as to whether or not there should be no discovery in arbitration, some discovery, limited discovery, unlimited discovery. And sitting as an arbitrator over a great number of years, I have found that the more facts, just like the jigsaw puzzle, the more facts that I have before me, the more accurately and the more justly and fairly do I believe that I can come to the right result in the case. That's just my view. I know there may be opposing views or different approaches, but that's just the way I've approached it.
I tend to, for the reasons that John listed, I tend to allow and want to have the parties doing thorough written discovery. I find that you can place limitations on the number of depositions that a party's going to go do before coming back to the panel to show good cause for anything more. And that seems to be the place where most litigants are willing to place limitations voluntarily or work with the other side to come up with some agreement on either number of depositions or number of hours of deposition. But the written discovery I find to be the more thorough, the better for the panel. And it's for us because we are the ones making the ultimate determination in the case. And when stones are left, and it's not to say that you can't limit on the front end what discovery is out there. If this is a contractor versus a subcontractor case and it doesn't involve schedule or delay, you can limit a lot, down to the scope of work involving that subcontractor trade. But if it's something broader, a schedule case, a delay case, or a much broader dispute, there often are times when I don't think it makes sense to limit because you really want the parties to get out there and get everything they need to be able to prove their case to you, or in many cases fail to prove their case to you. So I sort of draw a distinction there. And then there are other places that you can conserve. Like, do you allow a full-throated expert report, allow the federal rules, and then allow a deposition of the expert? I usually make the parties forego the deposition if they've got a full-throated report. And if all the expert reports are going to be thorough reports, then you can cut out, some or limit some of that type of discovery.
And I was going to just add to that, it's sort of maybe a middle between you and John. At the preliminary conference, I always talk about how discovery has to be material and relevant to the issues before us, which sort of goes, for instance, to your subcontractor example, but it goes even a little bit beyond. And it goes to, and Marion said she likes to see, who the witnesses are going to be. I find that that's extremely valuable because when we start with e-discovery and we start going down the rabbit hole relative to the discovery of emails and correspondence, I mean, how deep do you go within the project team relative to what is allowed and what is not allowed? And so I typically have the parties on, for instance, e-discovery on that type of thing, meet and confer as to who are going to be the key people within the matter, and that only those individuals will then have the searches done, for instance, on their emails or correspondence. Again, if an issue is not before us and there are facts that might be, quote, wanting to be known, but if they aren't immaterial and relevant to the issues before us, then that's where I also draw the line. I do like the parties to come up with their own discovery order, but I like to give these guidelines at the conference so that when they're developing that discovery order, that they do consider all of those in their presentation. Now, there will then be issues where that, quote, issue of it's not material and relevant, one party may think it is, and one party does not. That's where I really like the Redfern schedules. I use Redfern schedules a lot. And I really like then seeing each party put their position, their reply position, and then the panel make their decision based on that. So there's a little bit of twist from what the two of you have said, but that's what I would add.
I would add, I tend to not like written discovery because in California, it tends to be overly abused. Sort of a way just to be overbroad and burdensome and all that. So if a party wants written discovery, what I require them to do, it all depends on the case, is provide the discovery in advance to me. And then I can look at it to see if this is going to be relevant or just going to be objected to. Because if we're going to do written discovery, it should be done once, and I'd like to see no objections, and then we can move forward. But just in California, if you just do broad discovery, you tend to get, it doesn't tend to be very efficient. So that's what I do to try to narrow it. One thing I wanted to say for Tony, that situation with the jurisdiction, the other thing I always put in my preliminary order is I make sure all the parties consent to the jurisdiction and arbitrability of all matters that have been presented. So somebody can't come back later and say, well, I didn't consent to jurisdiction, because that can happen. And so that's, I always put that in the preliminary, make sure everybody agrees to that at the preliminary hearing. And then that tends to, less of an argument later if there was something that they contend is not part of your jurisdiction.
Back to the discovery issue, I think so much of it depends on what the contract says. And so much of it depends on what the parties and counsel have agreed to. I remember distinctly a wind farm case that John Hinchy and I arbitrated, multi-party case, where the contracts provided for full and complete, full-blown discovery under the U.S. District Court rules. And I know we spent a lot of time, John, discouraging the parties from following that procedure and limiting their discovery to what we thought was reasonable. I don't think that we were able to dictate the terms of that, but we were able to influence the council a good bit in that regard.
Yeah, I think I just need to maybe qualify, my view. When I say I want all the facts on the table, I want only the relevant material facts on the table. And in fact, whenever we talk about the parameters of discovery, I often encourage the parties to use the IBA rule, which is not only relevant material to the issues, but also relevant material to the outcome of the case, which is even a stricter standard. And when we have issues as to what that would mean, I like to have a full and complete discussion with counsel for the parties to tell me exactly what they are looking for. And if they can demonstrate that they are trying to find facts that are relevant material to the issues and to the outcome of the case, then I will, in most cases, generally allow it. So, obviously you can't have totally unlimited discovery. I mean, that's just, impractical, impossible, and totally uneconomical. But as long as the facts are relevant material, then I think, at least in my view, discovery should be allowed.
I had a really interesting experience not too long ago where parties were trying to limit their production of email through their ESI order. They had exchanged project files, everything else had been done. They had an ESI order where they agreed on search terms. Well, they agreed on the people whose email was going to be searched. And then they came up with a group of search terms. They applied it. They each went out, ran their searches, and they came up with like 280,000 email that they hit on when they applied the search terms. Well, they came back together and they said that's too much. It's way too broad. We got to redo this. So they redid their search terms until they got fewer hits, and they redid it and got like 140. And they agreed with each other that they were not going to produce over 100,000 emails to each other. So they revised the people that they were going to, whose computer searches they were going to use in the search terms. And then they narrowed a little bit the search terms to where they got down to something that was like 105 or 110,000 hits. And I thought it was really interesting. They just had a tolerance for a certain number of emails they were going to exchange. And they had project managers in there, but they knocked out a project engineer here or there, to get this down to this more manageable group. I'd never seen anybody do that before, but I thought it was an interesting way of going about it.
All right, I'm gonna talk about dispositive motions right now. And I think from my point of view, the biggest question is, I get the sense before certain arbitrators, they are a little hesitant to grant them just because they can have such a decisive outcome. I don't get the sense from my panelists today that that is a concern I would have to worry about appearing before you. But what are some of the most important things to clear up for an arbitrator to actually get dispositive relief granted? Marion, I'll start with you this time.
Well, I require the parties to provide a letter before they file a dispositive motion to give me a flavor of what's going to happen next and whether I think this will really streamline the arbitration process and is appropriate for a dispositive motion. So I think that's a good way to gatekeep and in a sense, not to, have dispositive motions flying all over the place. But I think they're important in arbitration, to be honest with you. I think there's issues that can be done on a dispositive motion, especially legal issues. And I think it helps the parties avoid a hearing. A lot of times if a preliminary issue is resolved, and I see a lot of times the mediation comes and all of a sudden there's no arbitration hearing. So I think it's a cost-effective way to streamline the process, and I'm very much for them. If it doesn't that's the thing, it's got to streamline the process. If I'm just going to be doing a mini hearing, and I'm just going to save it for the main hearing. In other words, it has to be, something that really can be dispositive and really can move the case forward in a streamlined manner.
All right. Well,
I was just going to make the comment that I think they are by and large very educational, but also risky, and I tend to be really reluctant to take away someone's right to put on some of their evidence. So I'm probably more hesitant than Marion. I also ask for a letter ahead of time and a response and try to delve through the issue pretty carefully. I have on a couple of occasions thought I denied a motion. I thought, that was really 50-50. Maybe I should have gone ahead and granted it. Then I heard all of the evidence, and I was really struck by how important the evidence was to me in the overall case, the evidence that I would not have heard had I granted the motion. So I think a couple of those experiences has made me way more cautious.
I come down on the side that Allison just discussed. I'm very, very reluctant to grant dispositive motions, especially if there's any colorable issues of material fact that are brought up by the parties. I'm very reluctant to cut off somebody's right who's agreed to arbitration to put their case on, at least to a certain extent.
I want to clarify that if it is a major question of fact, it probably will not be granted. I will not probably allow a dispositive motion because, again, you're not streamlining the process. You need all the facts to come out. If that's the case, then that has to go to hearing. It's more discrete issues that don't have heavy facts, a lot of times stipulated facts. I've had a couple of those, and those where there's a real discrete legal issue. In fact, I just did that where there was real discrete legal issues, and one way or the other is going to make a huge difference in the case. And the parties, so they came to me and asked me to decide those issues early so they could save the money, potentially not having to go to hearing and see where I was coming down on that. I thought that was smart of counsel to do that early. I mean, it's risky because, I went one way or the other, but it was a good way to streamline that case and potentially avoid a hearing.
Yeah, and I agree, Marianne. I think especially on some preliminary issues where I've granted dispositive motions and have granted them, the case has actually settled and has not gone forward to a hearing. And the feedback because one of these was a AAA matter, and the feedback from the case manager is both parties were very appreciative of the fact that the dispositive motion was heard. And they thought it was a fair process and that they were able to resolve their issues much more cost efficiently and timely than if the arbitration had gone forward. So it was good feedback. You don't always get that feedback, but I was curious. So, I mean, I asked the case manager if there was any feedback on that because I, was a little bit concerned. But it was very positive. And so it was, I think it was a good motion and a good result for the parties.
I recently had an international case where it looked like there was a pretty good statute of limitations defense on the whole matter brought by the counterclaim brought by the respondent. So what we did at the hearing was we let the respondent go first, dealing only with the issues related to the statute of limitation questions. And at the close of the that part of the hearings, the claimant restated their motion for summary judgment, which we granted. After saved about 3 weeks of hearing, but at least we let everybody be heard on it.
Well, I'll just add one thing, and that is there is a certain type of dispositive motion that can be very useful and is often granted, and that has to do with limitations on damages. We often see in contracts various categories of limitations on damages, either as to the total amount or punitive damages or consequential damages. Those are strictly legal issues typically, and often you can resolve those by motion, briefing, and argument. And if that is done during the course of the hearing rather than waiting until the hearing, then often you can shortcut a great amount of the discovery and a great amount of the time that would have occurred during the hearing. But those are a special category of dispositive motions, I think that can be usefully decided during the arbitration stage.
Makes sense. All right, I want to jump to the final hearing, and want to see what maybe some of your preferences are. If you know you're an outlier in certain areas, it's great. But I'll throw out one potential area to talk about, and that is expert presentations. Do you like it when the attorneys just turn the expert loose and they get to present on their own without many questions from the attorney, or do you prefer the more traditional question and answer style from experts? So that's just one example, but if you have any outlier opinions on how a final hearing should go, throw those in as well. And this time, Patricia, I'll start with you.
Thanks, Todd. Well, let's just go for the experts first. It's always a passion of mine relative to how experts are treated, and I don't wait to the actual hearing. This is something, as I talked about earlier, that I bring up at the preliminary conference. I think is it extremely important to nail this down early, because depending on the type of case, expert can take a lot of work relative to not only preparing their own reports, but working with each other if that is the case. I like to have the protocol set up. It doesn't necessarily mean that the protocol is going to be cast in stone at the preliminary conference, because after that discussion, there may be the parties want to go back and talk about how they're going to view the final hearing and how experts are going to be heard. But typically what I like to see is I like to see regular cross-examination first. I like to see them hot tub. I like to see them sitting there side by side. But I do like cross-examination. I think it helps counsel. I think counsel is makes them more comfortable that they have that cross-examination first. Then I like the panel to be able to ask questions. And typically on the panels that I have been involved in, while we may have a very discrete question to one expert, we typically meet and confer as a panel as to what the questions are that we as a panel are going to want to hear from these experts. And then we present the same question to the experts for each of them to answer to the panel. Depending on the case, depending on the issues, we may or may not then allow an expert to follow up with a question. Just finished a matter where this happened, and there were a lot of experts, very technical case, over probably 9 or 10 technical experts from each side. And it was important for the experts to be able to ask each other particular questions after the panel had finished their questioning, because it actually brought out some issues that I don't even think council thought of, let alone the tribunal, that really gave us some additional evidence that we needed during our deliberation. So that's how I'll handle experts. I like chess clocks. I'm very favor of chess clocks because I think that the arbitration hearing needs some structure. And I think it needs fair and reasonable structure. And I think everybody needs to know when they're going to go home. And I think it helps focus counsel in their questioning. I think it helps focus the case. And I really, really do like chess clock. I have both the parties take their own time, and I have the court reporter take the time and report that out at least 3 times a day, beginning of the day, lunchtime, and at the end of the day. And if there's any disputes, then they can be raised the next morning. Relative to direct, I'm not fond of direct. I like prepared witness statements, but what I do like is I like a witness to be able to be introduced and to maybe have anywhere from 5 to 15 minutes where they can, these are the topics that I'm going to discuss, or these are my major findings, or yes, this is the evidence, and yes, this is my witness statement, and I prepared it, blah, blah, blah. But I think it's important to give that person an opportunity to feel comfortable before they're turned over to cross-examination. It also gives you a little flavor. How do they do in that, 10 to 15 minutes versus how they do on cross-examination? It allows the panel to see a little bit of difference. In person versus virtual, I think it depends on the case. I have been involved in massive multi-$100 million arbitrations 2 weeks that have been virtual that have turned out absolutely perfect with no issues whatsoever. I've had others where a virtual probably would not have worked due to the complexities of the nature of the case, along with the different parties and the ability to really look around the room and see potential reactions or how parties are reacting. I've also been involved in one where one of the arbitrators, due to some personal reasons, was actually unable at the last minute to attend the hearing. There was some reluctance to do a hybrid with 2 of the arbitrators in person with everybody and 1 arbitrator virtual. But I will tell you that it worked out marvelously. And that arbitrator asked the same questions and had the same involvement as if they were there, and made no difference. So I have an open mind now. I may have not had such an open mind before that experience, but having watched that and having watched how successful it was and the parties being very comfortable with it, I would be open if I saw that again. So, and then just briefly, opens and closings. I like brief openings just to set the stage and tell us what it is that we're going to be hearing. And again, what are the issues that we're going to be decided. And so that's, but brief and closings, not necessarily. I'm not a favor of closing arguments. I would rather see post-hearing briefs, to be quite honest, where they can be hyperlinked and give me everything to easily look at between the exhibits, the cross-examination, the transcripts, witness statements, and that type of thing. So that's what I like to see on a final hearing, Todd.
Thanks. Marion, you want to go next?
Well, I agree with a lot of what Patricia said. One thing is I think direct examination, certainly from the side of the advocate, but also on the side of the arbitrator, is a very slow, dull, methodical process, and really sort of especially when you're in arbitration where everyone's very sophisticated. I think direct witness statements are fantastic. It's hard to get people. I always suggest it, but again, parties have to agree to it. A lot of attorneys are not comfortable with it, although it's just great. I agree with, so I prefer with experts, if they have a report, I tell them much earlier that will be, I want to treat that as their direct, so the report will reflect that. I agree, I do want an introduction to the expert and just a bullet point of their opinion, so at least sets the stage, but then we can move right into cross, which I think is really the most important part of the hearing, is really the cross-examination. But I have had, it's just a lot of counsel not familiar with that type of way of doing things, so I don't get a lot of people doing it. But the problem is direct tends to slow down the entire hearing, where cross can go very quickly, but direct can be like hours, and really not necessary. A lot of the stuff can be done in witness statements, and I do like But if an expert is to present, I do like PowerPoint presentations because again, it's just, I don't need, it's just gonna be a lot of leading questions anyway from the council. Let's just get the information out. The other party will have plenty of opportunity to cross on that, and it just speeds the process along. That's the nice thing about arbitrations. I mean, we can speed the process along where we can allow for little leading questions and things like that, just to keep the ball rolling.
Todd, one dirty little secret among arbitrators, which we don't like to admit or talk about, is that we miss a lot during the course of an arbitration. And sometimes we miss really important things. So I think it's extremely important for the advocates, the counsel, to make sure that during the course of their presentation of evidence, that they are getting through, that they are communicating with the arbitrators, and that there's no misunderstanding about what the witness is going to be testifying to. For example, in starting off with your witness, I think every arbitrator would probably admit that the closest attention paid to testimony is that very first witness at the beginning and at the end of a presentation. So counsel should be absolutely dogmatic about beginning and ending the case with strong witnesses. And they should introduce the witness's testimony by putting it into the context of the overall theme and theory of the case, because as we're listening to the evidence, we're trying to put that in context of what the issues are and what the contract provides. So to the extent that the counsel can assist us when the evidence is being presented, that's extremely helpful. Just one little point about the witness's background. Hopefully that's been presented prior by written testimony or in some other fashion. We don't need to spend a lot of time on the witness's background. You can produce a written CV or summary of that and then get to the heart of the testimony, because again, attention on the part of arbitrators is limited and it needs to be focused. Explaining or demonstrating various technical terms or processes that may be unfamiliar to the panel. The panel don't like to ask questions indicating that they've missed things, or because they don't want to embarrass themselves in front of the other arbitrators or the counsel. So it's very important that the counsel make sure that everything is crystal clear when it's being presented. The witness should look directly at the panel when they're testifying, and then speak very slowly and loudly to be clearly understood. All this is basic, but it's extremely important. And then keep the direct examination and the cross, for that matter, as short and succinct as possible. Again, because human focus is limited, and so the time that you are on the stand, that the witness is testifying, is precious, and it really needs to be focused, and it needs to be relevant, and it needs to be placed in context. So these are just practical tips for the advocate in presenting the evidence.
I would sort of reiterate what I think Patricia said about presentations by the experts. I tend to like the presentations where the expert you do 10 or 15 minutes of introduction, and then they start making their presentation. It should always be accompanied with a PowerPoint. It's one of the few documents I actually ask the parties to give me in hard copy form, is the PowerPoint presentation. I have found many experts to be very effective that way. A few not so much. I think we're all used to the scheduling and delay. Experts around the country doing that pretty regularly. So they're pretty polished and they do it generally pretty effectively. When the issue is something other than scheduling, delay, productivity, when you're dealing with some kind of construction defect or some other type of issue, a negligence or a gross negligence issue, that type of expert generally is not as used to making a presentation, I've found. and they're less polished in doing so. So I think counsel need to think through what the manner of presentation is going to be, how much experience that expert has had doing that kind of presentation. Because I think part of it is just something we see every day now. And then other issues are not done that way uniquely. And I actually had one done that way not too long ago in a fraud case. And I'd never had a presentation done like that in a fraud case. I thought it was fascinating. And it was like storytelling. You know, it was almost like a closing argument in a courthouse, but done by an expert, but built on the evidence and the documents through a presentation, you know, a PowerPoint presentation. Extremely well done. So I just think you have to focus in on what is your person doing and what's their experience level, and can they stay interesting, and can they make it interesting for the panel? Because by all means, they've got to keep your attention and keep you on it, and keep referring you back to the evidence, and keep taking you back to showing you how they've proved that particular point.
Just a couple of other points, Todd, to pick up on what John said. I often have counsel give me a 2 or 3 minute summary of why I've called this witness and why their testimony is going to fit into the case and how it fits into the case. And I found that very helpful to help us stay focused. To close out the case with the closing brief, I like to keep that solely focused on questions and issues that the panel has raised. Don't regurgitate the whole case to me again, but focus on these 4, 8, 10 issues. This is what we're interested in. And along with that, I want a form of award. I want both of the parties, each party to give us a list of the issues that they want the panel to decide and how they want them decided.
All right. I haven't left as much time as you all probably want to answer this question, which has been told to me by multiple people. I must ask you, even though I almost got my head bit off the last time I asked the panel of arbitrators this. There is a perception out there, I don't know where it comes from, that arbitrators sometimes split the baby. Obviously, I would imagine all of you disagree with that. Who would like to speak up first on behalf of arbitrators and explain why arbitration awards are not simply split the baby type awards?
Well,
I'm sorry. Go
for
ahead,
it, John.
Everybody
I feel very strongly about that, and let me just answer as loudly, clearly, and as explicitly as possible. No, not only no, but hell no. They do not split the baby. And at least in the classic sense of arbitrarily reaching a decision based on the amount of the award. But what they do, and they should do, is question each other's assumptions, and they should conduct deliberations whereby an arbitrator might say, for example, I feel that the damages in this case should be in the range of X dollars to X plus dollars based on the evidence, and that the arbitrators can have different views as to where that number should be. And in that instance, where it is based on the evidence, I think it is appropriate, and it's done all the time, of the arbitrators trying to reach a reasonable compromise, again, based on the evidence, based on their views of the evidence, but not simply flipping a coin or saying, let's have this, make it a 50-50 award. But in all cases, the final result would never be inconsistent with the evidence, and it would be the result of each arbitrator agreeing that the final award is consistent with the facts, the contract, and the applicable law.
Couldn't say it better myself.
Well,
I
and
think that covers it.
Agreed, 100%.
How often have we also seen judges and juries do split the baby? I just think that, any time you go in front of a trier of fact, there is a risk of that. But I think people when you go to arbitration, you're up against arbitrators have also been, most of the time, been advocates. And one thing I always remember is that I was an advocate. I was on the other side, and I remember what really upset me when arbitrators or any trier of fact would do just that, split the baby or do things that were not appropriate. Like, for example, arbitrator being an advocate. I've seen many times where the trier of fact ends up helping the other side because doing their own research and trying to like boost the other side because they're not doing a good enough job. That I really don't like. I hate that as an advocate, and I certainly don't do that as an arbitrator. You put on your case and I will decide the case. So I think that I think arbitrators tend to not do that because we've been on the other side of that. Let's put it that way.
Well, I think that's right. And I'll paraphrase what an arbitrator told me last time, which is basically that advocates don't do as good a job as they think they do of getting their client every dollar they put forth. So, well, we've reached the end of our time. I can't thank you all enough for this discussion. I found it extremely interesting. Hopefully you did too. And I'm sure I speak on behalf of, I think I saw as many as 80 participants at one point. We all thank you for your insights.
You're welcome.
Thank you for having us.
Thank you for having
Thank you.
us.
Ladies and gentlemen, this does conclude today's meeting. Thank you for joining and have a great afternoon.
Thank you.